Call into order the regular meeting of the Hubbardston Planning Board. Planning Board meetings are broadcast live and digitally recorded. This meeting is being held both in person and virtually through Microsoft Teams, pursuant to Section 20 of the Acts of 2021, allowing public meetings to be conducted remotely so that board and committee members, as well as members of the public, can participate remotely. And noting that we do have 2 members who are participating remotely, that constitute the quorum, and 1 member in the room. And because we have members virtually, all votes will be done by roll call. So, with that, noting that we have present for tonight is Mr. Carpenter, Mr. Steiger, Mr. Kresge, our alternate, the chair, myself, Mr. Monroe, and absent is Mr. Demalia and Mr. Holman, who gave notice he wasn't going to be able to attend. So with that, let's move forward into our agenda. So the first item is call for public comments for things that are not otherwise on the agenda. Do we have anyone here for public comment for anything that is not on the agenda, either in person or online? See, this is why we need to be able to see online to see if somebody pops up. All right, hearing none, let's move forward on the agenda, which is for acceptance of the previous minutes. The minutes have been made available to the board, both through the SharePoint, through the binders that are prepared for tonight. Our typical process for handling this is to get a motion and a second, and then proceed with any edits through friendly amendment. So with that being said, do we have a motion for acceptance of the minutes?
I'll make that motion that we accept the minutes.
Thank you. Do we have a second?
I'll second.
Thank you. And here in a first and a second, any discussion or corrections to the previous minutes?
No changes from me.
No changes here.
Excellent. All right, well, let's call a vote on that. So I'm calling a vote, and the vote is by roll, since we have members who are appearing virtually. Mr. Steiger?
Aye.
Mr. Carpenter?
Aye.
And the chair is aye, so the minutes are accepted. Moving forward into the agenda, we have the planner's report. Alec, do you have anything for the planner's report tonight that isn't otherwise covered in the agenda?
No, I'll yield all my time to your consultant this evening.
All right, thank you. All right, so that brings us to new business, and we really only have 2 substantive things that are on the agenda for tonight. The first one is going to be the review of the proposed overlay language, and then the other one is discussion of the Massachusetts Integrated Land Use Strategy. I'm actually going to take those out of order because I believe that B one's going to be pretty quick. So for anyone who's not been following this, this was just presented, well, this hasn't really been presented publicly other than at the RPO level. The state is rolling out with what they're calling the Massachusetts Integrated Land Use Strategy. The acronym for it is MILUS, or MILUS. It's being run out of the Executive Office of Environmental Affairs. So the Undersecretary for the department appeared at the last MRPC meeting and announced the rollout of this program. And what this program is going to do, it's going to create a new GIS layer that essentially has zoning recommendations for the entire state based upon state objectives that have been set by the administration, such as building 500 gigawatts of energy storage, and then meeting the housing production goals of 225,000 units. While this is not something that's being positioned as being mandatory on the towns that are going to be covered by it, state funding is likely going to be linked to it. So when folks go looking for grant applications for certain projects and stuff, they are going to be looking to see that those projects align with what the state defined goals are for those areas. And the state is going to be working with MRPC and some of the other RPOs to try to define some of these areas. But the main driver behind it are the broader goals coming from the administration. So there's only a little bit of information available about this online, and you can find it specifically by Googling Massachusetts Integrated Land Use Strategy. And I believe there was a handout in the drive that was made available to everybody.
It's in all your packets.
Yeah. Is it possible? Was there just a comment online about
I
that?
think it was just a yes.
No, okay. Okay, so yeah, I certainly encourage everybody on the board to take a look at that, and I certainly encourage members of the public, either in the room or listening, to take a look at that, because that potentially represents a pretty massive policy shift, and is probably, depending upon what folks' personal beliefs are, probably another step away from the home use rule. So we'll see where it goes. Obviously, keep an open mind about it, because there'll certainly be some grant opportunities that come out of it. But the goal is very, very clear, to come up with an overall state-based zoning scheme. So, any questions or discussion on that?
Do you have any idea what the major driver behind this is? Is it affordable housing or
Yeah.
Yeah, affordable housing is one of them.
infrastructure or what?
So there's 4 goals, and one of them is the 225,000 units by 2030, and then the other, I think it was 2030, and then the other one is the 500 gigawatts of storage. There is also a goal for conservation, which is actually pretty ambitious. It was something along the lines of 60% of state land being designated specifically for conservation. I'm seeing if I can get those goals for you right now while we're talking. But there are 4 goals that, and these have been public goals for a while from the administration, but this is a strategy to actually make those goals a little more actionable, other than what's currently going on with some of the regulations around battery energy storage systems. But yeah, it's certainly something we're going to end up talking about a bunch more as time goes on, and I'm sure it's going to hit a lot more of the planning forums and a lot more of the MMA forums. I believe the initial launch has actually just been to the MPOs, so it's only been talked about at the level of organizations like MRPC. I'm looking right now, it doesn't list the specific 4 goals. They were supposed to send out the slide deck, and when I get the slide deck, I'll certainly share it with the board, which means that obviously any members of the public could ask for it if they wanted to see. But yeah, it's a pretty meaningful thing. That's why I wanted it on the agenda. So, any other questions or discussion on that from the board?
No.
And I guess just for the sake of conversation, for the engineers presenting, have you guys heard anything about that yet?
Nothing beyond what you shared. Nope,
Yeah.
it is newish to us as well.
Yeah.
Limited in detail.
All right. So with that, let's move backwards on the agenda to review niche proposed overlay language. So you want to come up to the table?
Yeah.
And just noting that this is a presentation of the deliverable. It's not a formal public hearing. We'll obviously take public comment, we always do. The way I would like to proceed is we'll have the consultant, we'll have Alec present questions from the board, and then we'll come around to questions from the public. So let's go ahead and proceed that way.
Sure. I wasn't planning on presenting because it's been transmitted a few times, so hoping to just open it to questions. But I'll give a brief overview of sort of our charge and what the impetus of the overlay project was about. By way of introduction, my name is Brian Creamer. I'm here representing Niche Engineering. The town put out an RFP. I'm blanking on the date. I want to say August, maybe September. Which was funded by a $50,000 state rural development fund grant, really testing my memory. And we've been working with the town for the last maybe 4 or 5 months on setting forth 2 public engagement sessions and really soliciting feedback from the public about what the public would like to see on the sand pit overlay area, which is essentially about 700 or so acres, if I got the acreage right. Yeah, in the northern section of town. I think there are certainly maps to support that, but and set forth a few development schemes. We got plenty of feedback on the schemes themselves, and then the overlay language is certainly in draft form, and looking forward to having a discussion tonight through what we've come up with.
Right, thank you. That's exactly what I was looking for. I wasn't looking for you to
Okay.
take us through the whole thing. So let's start turning to the questions. So Al, can you, let's start with your questions.
I have no questions at this time. I'm going to let the board ask mostly their questions. I think that's where the value is going to come out of this tonight. And then as I have follow-up questions, I'll put those in writing back to your consultant tomorrow.
Oh yeah, absolutely. And just to clarify, it said Al, not Alex, so I apologize. Mr. Carpenter?
Yes,
Uh,
you want me to,
Yes.
you want me to comment?
Yep.
Oh, goodness. Okay. Well, let's start at the beginning. I believe that we heard from one engineer in the town who spoke a couple of months ago about a piece of this land that we're talking about being south of Pitcherville Road and being an ideal location for a potential well for the town, and also that it is primarily wetland. I don't know, I haven't walked it myself, but I just say at the outset, maybe we need to look at the boundary of that piece and see whether we see a value in excluding that from the, the overall overlay. With that said, I was curious about why we see value in merging what appear to be two different types of overlays, one called enhanced residential agricultural and one called neighborhood, into one overlay district called R2GO. Are these two categories meant to be separate overlays, or are they just different use categories within the same overlay? I'm not sure if I am clear on that.
It's the latter. So it would be separate use categories within sort of the one singular overlay. Fundamentally, I think it's to ease potential confusion around multiple overlays over a single area. But baked within the proposed, overlay, I shouldn't say proposed, but, drafted overlay, there are multiple use cases that are either allowable and have certain stipulations with them.
So it is conceivable then that some developer who had ownership of the whole 690 acres or whatever could propose to have only a neighborhood mixed-use development, or the alternative, that it could be only an enhanced agricultural residential development proposal.
In that scenario, yes, that is if the land were to be under a single ownership, which it is not, but yes, that is conceivable.
Something for us to think about, I guess. Okay. To get into the details of what's drafted, I think under applicability, there's a question I have about the statement that what part of code would be precedent, so to speak, or superior if there's conflict between existing regulations and these new proposed overlay regulations. I think we intend that these overlay regulations would be superior to any existing regulation. Am I correct in that?
Yes, superior in that they offer different density levels than the underlying zoning. That said, the underlying zoning would still be applicable, right? That just as is case with all overlays inherently. So I don't know if that answers the question of what's superior or not, but it doesn't presuppose the underlying zoning.
One might interpret or misinterpret misinterpret our intent by looking at existing residential regulations and applying them because they appear to be stricter than what's conceived of in this overlay.
Right.
And I think that's the thing I want to make sure we don't misunderstand or misstate here, that's all.
Yeah. Can I jump in here, Alan? Because
Yeah, sure.
This is I was very curious about this issue as well, and what the legal niceties are for having two overlay zones on the books simultaneously that apply to the same geographic area that have totally different intents and are contradictory. At best, it seems confusing. At worst, it seems challengeable as arbitrary and capricious. I'm talking specifically about the Aquifer Protection District, which, when it was passed, was with the notion that groundwater protection was important and that they were going to make requirements stricter than base zoning. And now we're saying that development is important and that requirements are going to be looser than base zoning. So, I mean, legally, I guess the new one takes primacy because it has language in it that says this supersedes everything prior. And that if it gets passed, then that becomes the new.
I would defer to town council on that, but if the rulemaking is done at the same level of authority. It's an interesting question.
Yeah.
I also don't have a good answer for that. Not being a land use attorney, I don't know which would take. I don't know if this presupposes the Aquifer Protection District, I guess. But I hear you. It is at best, yes, odd to have two alternative pathways, I guess, right? Well, fundamentally three, right? The underlying zoning and then the two overlays.
Yeah. But it's probably something we should think about as we move forward.
Yeah. You know, it's a good question.
Yeah.
Okay, anyway, in terms of the word stricter regulations will prevail, we need to make sure that that's consistent with our goal of having the overlay allow for different types of residential and or commercial layouts than what currently is allowed under our existing zone. On page 2, the table, at first I was a little confused, but our existing zone is referred to as residential agricultural. And just for consistency, maybe we should follow the same order in nomenclature. And
Oh, yes, got it. I see it now.
that the word enhanced worries me a little bit because that's a subjective term. I would prefer something like alternative, only because we're not trying to make a judgment as to what's best or we're not. And it's just strikes me as the wrong way.
Yeah,
That-
but enhanced certainly does have a more favorable connotation to it. I will disagree with you there. And
Yeah, I don't know. Anyway, under neighborhood, do we still intend that it be construed as mixed use?
yes, but we intentionally listed many of the mix of uses that are non-residential as, allowing this board to have the special permit granting authority. That said, there are a few by right non-residential uses
Okay.
in here.
Sure.
And
I-
to be fair, maybe that
Again,
one-
nomenclature to me is kind of important. I would prefer it be called neighborhood mixed use.
Yeah.
Only because that really tells the people what neighborhood means.
Okay.
That's just, again, others should chime in. I'm happy to have a discussion if you think I'm off base. I would, under the uses related to the residential agricultural column, I'd like to see something added which is accessory uses of agricultural allowed under Mass General Law, Chapter 40A, Section 3. Because we've got all these eco tourism things, but we haven't included the little stuff, and I presume we still want to move in that direction even in this code as well as its own separate code. Does that create some problems for you, Alec, or anyone else? No? If we could add that, that might be clearer to people that we are sensitive to the fact that they value the agricultural business opportunities as part of this overlay.
Al, if I may,
Yeah, sure.
so that's something that some of the subcommittees and advisory groups and such have talked about quite a bit. And part of the challenge that comes up with doing that is at the time we first started talking about it in the advisory committee, and I'm talking about the Agricultural Accessory Advisory Committee, not this particular overlay advisory committee. There were changes going on in a state law level. So the idea of just taking the list over from the state, it didn't really work. So I want to say we had looked at language because this is state law, it comes in under the Dover Amendments anyways. I want to say that Chapter 48 pulls in, it's like Chapter 128, Section whatever, and that's where the definitions of agriculture and agricultural accessory uses are. I guess what I'm saying is specifically listing the uses is probably impractical because they're tied directly to state law, and the state law is a moving target.
But maybe under 4 permitted uses, it could be a sub-bullet that specifically addresses those sections of MGL to just reiterate that those are allowed, presumably, right?
Yeah.
Okay.
I got a little confused by the term agricultural support services, which I thought was an umbrella which might be inclusive of what's already allowed by right under state law.
Fair.
Yeah, it gets squishy fast on that because when we had looked into it, it was like, well, there's a lot of things that are farm accessory uses that conceivably come in under state law, like crop dusting,
Right.
and an abattoir, and like it gets squishy fast.
Okay.
Can I clarifying? Is the agricultural support services ambiguous enough that we ought to actually maybe exclude that from a use that's allowed, or address it and have it be a special permit use, and then let the board decide on a case by case basis what that use, whether it's considered a support service or not.
So
That would put a lot of power in this board, right?
yeah, so I was going to save this for my comment section. I have some concerns about trying to go for some of the ag accessory things, and I know they got incorporated, and because it's something that the board and the town have been looking at for a long time in different shapes and forms. But I believe the intent is that At the upcoming town meeting, we also think we would be presenting a more traditional agricultural accessory bylaw instead of the broader ecotourism one that failed in committee. So I don't know. I think this potentially becomes more problematic if it tries to be more things to more people. And it probably just needs to be straightforward because, and a good example of that is the special event. So routinely in this town, folks are holding special events that go up to the farms. If you count it as number of people through in a day, as opposed to who are there at any particular moment, the average farm having a craft fair is hitting that number. So that got strong opposition from the farm people, and then it simultaneously got strong opposition from some of our constituents that live around the farms because they were like, well, 350, that's a huge event. It's like, yeah, but it's kind of happening right now. So it forces a conversation that I don't think has to be had in the context of this, when there's going to potentially be a parallel proposal. Because the actual Agricultural Commission says they're going to have a draft over to us to present, in addition to one that we're working on ourselves. So I think that's going to be pretty thoroughly litigated in the public.
Yeah, so strike it here then.
Yeah, but I'm just one voice on this, and I'm also interjecting in Al's comment time. So, but that's the overall concern that I have with it. That,
Okay.
Yep, proceed.
I don't. Okay. Well, my other question was, is this threshold of 4 events per year something, special, or should it be more than once in a year? 4 times a year, I know, just seems kind of arbitrary to me, but.
Yeah, exactly. That's the kind of discussion that comes up from it. And Mark was also on that advisory subcommittee, and can also attest to the fact that we spent hours talking about that 350 and the number of times per year, and the various constituent groups never came close to alignment on it.
Got it.
All right. Well, I'm stepping into all the thorny issues here, I guess.
And just, Al, for your benefit, what that number ultimately got tied to is somebody had done an ad hoc parking analysis, and that is the number of people you can reasonably fit if you're parking on 1 acre. And that was just arbitrarily what it got tied to.
Say what? You can put 350
People.
attendees on
Yeah,
1 acre?
assuming average occupancy, and 350 people, you can park them on 1 acre of land.
Wow. Oh, I don't want to have to park there. Okay.
I don't know, 6 people per car? It wasn't my calculation.
Oh, I get it. Oh, okay.
But that's what it got tied back to. But that's just another example in how I think that takes something that I think is an unnecessarily contentious issue and distracts away from the main conversation here.
Okay, well, we'll have to think about how to avoid controversy there. I was curious, the next comment had to do with campgrounds. We see rural campgrounds requiring a special permit. That struck me as being over our bearing and little. Yeah, I mean, rural campground.
I think that
I don't know,
behind
just
not allowing it
kinda
by
think
right.
that-
Oops, sorry.
I kind of think it should be by right. And then I dropped down to the latter section, which has hotel, motel, inn, and campground, and I think we should strike the campground there. I don't think we're going to have any campgrounds on anything other than rural surrounding areas, right?
So just from a point of history on that, I believe there actually have been some contentious camping situations in town over the years. which is probably part of that. But to the point, I don't know that rural campground is an actual defined term. And campgrounds themselves
It
are
actually
already-
is.
Is it?
That came up in our meetings. Katie was all up to speed on that there was a category of rural campgrounds versus primitive campgrounds. It was a whole thing.
What's the difference between a rural and a primitive campground?
I don't remember. It was
Water, I think. I don't know. I suppose, does rural have water and electric ties? I don't know.
It's just another layer of the onion that
Yeah.
I tend to agree with you that it doesn't necessarily belong in this effort, but
Yeah, Ooh, there's a lot to unpack politically on that one. It is potentially a little bit of a distraction. Like I said, a lot of the agricultural accessory uses.
Are already,
Yeah, they're either already allowed or they fall into that bucket of being potentially very distracting. Or will also be presented in a parallel article at the meeting.
okay. Yeah.
let's have more,
I
let's have more
think
separate
the issue
articles that
is we
apply to
don't
the
want,
same area.
It's not an overlay. An
Are
accessory
we-
definition is not an overlay.
I guess we want to avoid year-round campgrounds, and I guess I would, if we qualified it in any way, I would just say seasonal campgrounds, but it's not meant to be a trailer park or anything like that.
One, and that's ultimately where there was historically an enforcement issue. And where in some situations there are still enforcement issues. Where somebody will have a situation where they will have 3 or 4 RVs. And we do currently have bylaws that already prohibit that. So it's not that it's allowed under our current zoning or under our current general bylaws. But that's probably the perceptual problem with it.
Okay, so that was my concern, was I wasn't sure we needed a special permit, but maybe we do. What is a non-motorized active recreation?
Horseback riding, biking, sort of, all, hiking.
Okay.
Is it
I
a
don't
use?
see-
I hear you. It is a stretch to call it a use of a property. I guess the intent behind making sure that this board had purview over it is if any of the non-motorized uses became noxious, dangerous, sort of, otherwise needed more purview. That's why we specifically addressed it. And I think this one was also a use that was identified in that rural enterprise overlay.
Yeah.
So
I
that's
think it's fine that it's highlighted. I think I would like a check there rather than a special permit. But maybe I'm alone on that.
Wait, where is?
it's at the bottom of agricultural.
Non-motorized active recreation, horseback riding, etc. I think, it should be a planning board hearing and review, but not a special permit application. I don't-
Right, but
It's the last item under
if the active
agriculture,
recreation
the
use
top part
became
of
a leased soccer field, I think there's one in Lancaster that people may be familiar with. That type of active recreation, that would be a different land use than horseback riding, right?
Yeah, well, and I would also propose that horseback riding, as long as the stabling and rearing of horses going there, is a Dover Amendment protected activity.
True. All right. Yes, maybe that's a bad example.
That came up specifically because our Article 4 actually had the stabling of horses as a special permit use.
Oh, you can't.
Yeah, you can't do that.
Okay.
That's defined as agriculture under Chapter 128 or whatever the reference was.
Could I make a comment?
Okay.
Sure.
Um,
Well, we're going to take a brief comment in the room.
Yeah, just my understanding, especially with state grants, is that active versus passive recreation. Active recreation implies you have to somehow alter the land. Soccer fields, baseball fields, tennis courts, that's active. Passive recreation is hiking, horseback riding and hiking, things that you don't alter. So to include biking and horseback riding and hiking in active recreation, confusing.
Sorry, I mean them, think of an example where, when I say mountain biking, I don't mean on trails, which is, I totally agree with you, passive in nature. I'm thinking of like a BMX or a pump track style mountain biking activity, right? Where you're physically creating and doing earth altering. Horseback riding in a, I don't know how much, obviously we're not talking about a horse racing circuit, so I really
Yeah.
I
regret bringing up horseback riding, because I'm not an expert on horseback riding.
somehow altered the land. And
Yes.
used it. Okay.
Yep, I agree with you there.
And please just note yourself for the record.
Jassy Brackett, High Street.
All right, proceed, Mr. Carpenter.
Okay. Under services. Again, I think these subcategories may be bolded or something to make sure I got a little confused what agritourism, retails, office services, and other meant. But anyway, nursing, convalescent, and rest homes, special permit. I don't know. It may be alone. I think that in senior residential development, maybe things that we should expect would be appropriate for a location like Hubbardston, and maybe we want to encourage that and not make it overly regulatory burdensome to the applicant. Mainly because the nursing, convalescent homes and senior residential development, have certain characteristics that are more advantageous for us, such as not having school children generated in therein, etc. So I'm not sure. My own feeling is maybe we should allow that as just a planning board issue and not, have a special permit requirement. Everyone's stunned, I guess.
No, we're just absorbing the weight of the comment.
Yeah, okay, it is just that.
Wow.
Now, with respect,
Looked like we
moving
did have a
forward
follow-up there, Al.
Go ahead.
Well, I would think the applicable question is, are you regulating based on impact to the neighborhood, or are you trying to encourage certain forms of development? I mean, in terms of number of units and parking requirements and all that, a nursing home is no different from a hotel or a senior residential development. But maybe for social purposes, you want to make one easier than another, but they all have the same impact, which was the genesis of zoning purpose.
That's the issue. You hit the nail on the head. I look at the demographics of the region, in particular in Hubbardston, and I say it's an older community. Maybe it's by sort of young and older community mix. But one of the reasons that I think people would find Hubbardston attractive as a nursing or rest home location would be its relative rural characteristic. So I was just thinking of it as a more preferred option for further residential housing, as opposed to other types of residential development.
So,
Okay,
Well, before we go, so what's your suggestion there?
My suggestion
Yeah.
would be to not require a special permit.
I mean, where,
But maybe that's too liberal.
well, where I think there's potentially a challenge there is to the extent you're talking about a skilled nursing facility, you're talking about a healthcare facility, which
Yeah.
is certainly something that requires town involvement because of the municipal services that are also involved with it. So to the extent
Okay.
that it should be something promoted, I don't find that disagreeable, but, and I guess to the extent that it should at least have site plan review or some kind of special permit. We're also talking about something that's a multi-million-dollar endeavor. These things are tens of millions of dollars to build. So a special permit isn't necessarily that material of an impediment. Considering it's something that's already requiring plans, it's likely requiring approval from Housing and Urban Development from the feds, and it's going to require a license to operate from the state. So a local special permit is the least of the problems compared to getting the state license. And figuring out stuff like ambulance staffing and those kinds of things are pretty meaningful municipal interests. Where I think, and we can all feel free to disagree on this, but where I think that there's an opportunity here is I don't think that addresses the idea of assisted living, whether rest home constitutes assisted living.
I think this was intended to view that as a separate use, independent of a rest home. Rest home meaning full-time staff, in essentially a hospital facility.
Yeah, because assisted living is kind of the compromise there.
Yeah.
Granted, assisting livings usually have SNFs
Some
attached
sort
to
of-
them.
Right.
Okay, I wouldn't quibble with that. I think there are some unique characteristics to the nursing and convalescent type community. However, the senior residential development, I guess, then would be sort of like a senior HOA or condominium association. I assume that's differentiated from those that require health care and support.
Correct. Yep.
So just to clarify here, so we have the fully supported, we have the unsupported, we don't have like the middle ground. So assisted living does not appear in there. That
No.
seems like maybe it should. Unless they're...
And should care, well, I'm with you. I think it should at least show up in the use table. Then we can talk about whether it's a special
Yeah.
special permit or as allowed by right. It should probably follow suit with, well,
the more intense uses.
yeah. But
Okay. On the subcategory where it says other, I think we should just label that the planned unit development. All the
it's the only
following
use. Yeah,
text
that's
seems
fair.
Yeah. And just before
to be,
we get too far away, but because we've essentially been walking through the table, and I assume other folks who have comments on the table have felt free to interject them. Daycare center. I know that towns can do like design restrictions, but I don't think a town can actually restrict it.
Similar to Dover.
as otherwise being, yeah, because it's a Dover use. So why does it get a check mark in one of them but not the other? And I know that there's all kinds of conversation about, wow, a daycare center with like a commercial daycare center versus like a home daycare.
Right.
But those are things that can ultimately be specified through design standards.
I don't have a good answer for that one.
Yeah, because I think we actually revised our Article 4 a couple years ago in order to be more in line with what the updated Dover amendments were. I
Yeah,
have no
so the-
idea what that language was off the top of my head.
And this is essentially in line with the
Yeah.
Dover, it's just that it really doesn't bear putting in here.
Yeah.
Okay.
And then I guess before we move off the use table, did anybody have anything else on the use table?
To go back to Al's original question, so are these two categories viewed as different geographic areas of the overlay? Or are we just artificially creating categories of uses here?
They, the former, they're distinct geographic areas within the overall overlay. And that would go back to a map that I don't
Okay,
have, of
all
course.
right, so
Right?
that makes sense, having
Yeah.
them as separate then.
Yeah, I'm looking for the map.
Yeah.
Thank you, of course.
Okay,
That's the-
I'm all for that. Let's be clear, they're two different areas.
And hopefully that's in line with what I was saying at the beginning, when you asked a similar question, though differently phrased, but yeah, there's areas of the 700 acres that are more suitable to alternative residential agriculture, and then there are other areas, likely closer to 68, that are more conducive to a mixed-use neighborhood. Okay.
Yeah, they're the ones that align
Right.
with the option B selection from a few meetings ago.
I have posters in my office.
I know, and I thought I had them right here on my computer, but
So these are really subzones within the R2GO zone.
Correct.
Is that what we're saying?
Who's this one?
Yep, I think so.
It's in black and
Yeah.
white, so it's hard to see. but-
Thank you. Yeah.
Okay,
Actually, we say that in 2C, under applicability.
when we print the new zoning map, it's going to show two distinct subzones.
Correct.
One which is principally on the Pitcherville side and one that's principally on the Gardner Road side.
Correct, and so our terms are straight, right? They would be essentially hatches over the underlie, but yes. If anybody else wants to take a look at it. Sorry, that's the only copy we have.
They're in the board's packets. I can pull it up and share my screen.
okay, well, proceed on.
Do you want to continue?
Yeah, sure. Well, unless anybody had anything else for the table of uses before we move off of it. Yeah, continue.
Okay. The on-site processing of sand and gravel. Do we need to reference our existing town bylaw in that section? Is it relevant or is it overly restrictive for an approved project to have those? I mean, I'm not as familiar with the details of the existing earth movement zoning rules.
I tend to agree with you there. It couldn't hurt to reference the town's existing sand and gravel bylaw. This fundamentally is included to prohibit truck traffic on Pitcherville. Let's call it what it is. I mean, it says so in the last sentence here. Or at least limit it, right? Maybe not prohibit it. Functionally, you may have a truck leave that way. If the road were developed that way, but the ideal is that trucks are not traveling through Pitcherville.
Given the fact that this is probably a pretty long-term project if it's developed, I think we might want to include some hours of operation.
So there is a currently existing 14-page earth removal rules and regulations.
Yeah, but following the model of how you approached this with the density, dimensional stuff, if you would have to say here that this supersedes the Aquifer Protection District, since commercial earth removal is prohibited there.
As far as import of material is concerned, which is prohibited the way this is drafted, I think we have to be clear that we should allow import of fill or topsoil at least for a project like this.
I don't disagree with you in premise. Yes, like I don't know that it should be in that section, but
So that's also not the imported materials for processing.
Right.
So the imported materials for processing would be like the difference between running extraction and running an asphalt plant. Because importing materials and importing aggregates or importing stone to crush is very different from bringing in just soil to grade off. Because that's not processed.
Fair enough. Okay. Very good. Number 5, planned unit development option. This is principally about housing now. Where do these live? Why do we need these limits on the percentage of maximum allowed townhouses and multifamily dwellings? We already have significant restrictions on, I think, the amount of open land offset set aside, which I think was 50% or something like that.
Yep.
So, if we're going to 50%, and I'm just a little worried that this, we shoot ourselves in the foot by making it economically unattractive at the end of the day. That's a question, not a conclusion.
is the potential suggestion, I guess maybe where you're leading, and tell me if I get this wrong, but it's to either remove or increase the maximum share of each housing type, or just not address housing types themselves.
Yeah, I'd be open to either one, but I think I don't know how others feel about the kinds of housing that are going to be built, but I'd almost rather see it deleted, to be honest with you, and leave it to the special permitting authority and review to negotiate those issues as appropriate, as long as we maintain the standard of open space and protecting the wetlands. I think there's going to be enough challenges already to make it work out.
Yeah, but I suppose the other way to do it is to qualify it more generally as the town would like to see a mix of housing types, right? And potentially list them, but not qualify the specific proportion of development that shall be as, a maximum of one certain type.
I think that might make sense.
What does the rest of the board think about that?
But fundamentally underlying, sorry to interrupt, but multifamily is not allowed at all, right? So this is a huge change from
Yeah.
Yeah, I was about to make that, my broken record comment.
That's why I was looking at you, because you were clearly having a thought.
Yeah, I mean, it's just another, I mean, somehow you're going to have to address the elephant in the room, that these two uses, or these two regulatory approaches for this area of town are diametrically opposed.
Yeah. Wait until we get the third one from the state, whatever that turns out to be.
But yeah, then it'll be a triad.
They're going to come back and be like, this should be energy production land.
Right.
Yeah, well, and that's kind of the challenge of all of this, because a lot of this has grown up kind of organically in a little bit of a reactionary format. The other thought is, with this kind of zoning and this kind of planning, we're looking at like a 10-year plus range, as opposed to, are we zoning this for somebody who's going to build a project like right now? Like, yeah, there's a developer who's certainly interested in doing some stuff with his lots, but that's not really the genesis. The genesis is, we've been meaning to do something about this for a very long time, and the can's been kicked down the road. And yeah, there is that conflict, and it's going to have to be sorted out. But this is a step along the way to forcing the discussion.
Mm-hmm.
I
Okay,
imagine,
well,
under the current regulatory environment, that it would probably be an interesting time trying to challenge some of our prohibitions against multifamily housing. That if that was to be tested in court, it probably wouldn't go the town's way.
Right, so this sort of takes it, the not to call it a baby step, but a baby step, for lack of a better term, of 85% of it is allowed as multifamily, but the developer, I mean, provided they're willing to go to the 20-acre continuous, so there's several other qualifiers in here, but 15% of it needs to be single family. It doesn't dictate. That could be a starter home, 800 square foot style, smaller, single family. And maybe these percentages are wrong, right? I'm not, necessarily trying to defend that the maximum share needs to be 60 or 25. But the intent here is to sort of help a developer get closer to the rural character that we heard loud and clear in public comment, while still achieving, right, other goals of more dense housing typologies. But maybe selfishly, and I do what I explained, like maybe we are trying to have our cake and eat it too, and maybe this is not the place to do it. So I hear you. I don't have a good answer for that one.
I thought that was Francois coming off mute to solve all of these problems with one clever comment.
I have a question regarding why the single families were not included in the uses and limits. So it says the following housing types shall be allowed within the PUD. And the only ones mentioned are the townhouses and the multifamily dwellings. And there's no mention at all about single families.
It's true. So the presumption then is the developer would either do a subdivision that is the 80,000 square feet underlying zoning, or this PUD. There's two pathways to single family development. In the
But it
use
could be
table, if we list out single family, I guess inherently we would have to allow it by right in this neighborhood mixed use zone, subzone, sorry.
I mean, which,
Well, the first paragraph on the purpose of this says that it applies to that subzone along Gardner Road,
Right.
where you're trying to drive it to mixed use and denser use. So you probably don't necessarily want single homes in that particular subzone.
I mean, ideally, in my mind, higher density while preserving more land is really what the consistent theme is. Because the thing the board certainly did not want to see happen when everybody agreed on it, when everyone was here, was that we don't want to see this area checkerboarded off into just 2-acre lots or small lots. That's the outcome that is really bad for everybody. It doesn't conserve the land, maximum use of resources, maximum use of town resources, but going higher density and preserving more potentially makes sense, so.
But Francois, back to your point, if single family were a use that's allowed, we'd then have to stipulate how that's different than the underlying zoning's, lot size, essentially.
Well, I'm just pointing out that in item number 5, underneath, you say the single-family detached is 4 units per acre, right?
Right.
And so wouldn't mathematically, wouldn't we be able to also come up with a percentage in terms of what we can theoretically put in that PUD? To me, it sounds almost like you're excluding, where it says uses and limits. Number 1, the following housing types shall be allowed within the PUD. By not including single families, it sounds to me almost like you're excluding them. But yet, underneath there, under number 5, there's a density
Right.
that may be concentrated in the development.
Yeah, I see that.
Yeah.
Thank you. Don't take my not responding as a yes, heard, and I tend to agree with you as well.
Then I'm not that confused on number 4. It says residential density within a PUD shall not exceed 3 dwellings per units per acre, calculated over the entire PUD tract, right, including the land preserved as open space. So, I'm assuming you've done the I just haven't taken a calculator to figure things out here, but
Sure.
I'm assuming that if you take a 15-acre lot, which is, I think, your minimum, and then you say
20.
that,
20. Yeah.
sorry?
20 acres.
It's okay. Yeah, 20 is the minimum, but I hear you on the math. So,
Okay. I'm assuming you've done the calculations here and you've come up with something that says that, yeah, based on this here, we would be able to fit something in there that allows us to have total number of units that we plan on putting in this acreage and not exceed that 3 per acre and still be able to comply with what the goal is here. For me, it's just, and don't get me wrong, I appreciate the effort that you put into this here, but I just received this here today, and I have not sat down to look at all of the various different possible combinations of things and the percentages that you state there. But I'm assuming this eventually pans out into something that makes sense. The reason I'm also bringing this up is because when I go back further down onto number 7 under the open space residential development, there's a whole section here that additional open space for each 10% of open space permanently preserved above and required minimum, a bonus of 5% additional units may be granted. Again, it's just, for me, it's just extremely difficult to just in my mind say, okay, well, this makes sense because there's just a lot of numbers here. And when I look at the numbers above, I don't see this here. I would love you to see if you could come up with some examples where you can show, yeah, if you add this additional space, you get an additional 5%, and this is how a sample development would look. I just find it very confusing when I look at number 7B, 7B sections 1 through 5 with all of the additional bonuses that you have included in here.
Right.
I'm not saying that they're wrong. I'm just simply
Right.
saying
No, I hear
it's
you.
hard for me to grasp.
If it's giving you a headache, right, I imagine it would give a developer that is intending on building housing a bit of a headache too, so I hear you.
So that's just my point. I'm not saying that it's wrong. I'm just simply saying is that for somebody to look at this here and see how this all can make sense, and how do you put this into a spreadsheet, for example, and say, okay, fine, now I add this here, I take this away, this is where I come up with.
I've seen regulations somewhat confused by this issue of trying to define how many acres, how many dwelling units per acre, and then further trying to define how many units should be allowed per developable acre, right? And without a site map and engineering drawings of, the boundaries of wetland and so forth and so on, the two may be, I think that's part of what Francois' concern is. It may be difficult to really anticipate 3 and 5 together. 4 and 5 together under Section 5.
Yeah.
It may be only necessary to say there shouldn't be more than X units per acre, period.
Yeah.
Rather than say, how many per developable acre and that kind of thing.
And frankly, I do also believe that the special permit process itself is the venue by which you can work out what will be eventually permitted. Otherwise, I think that when somebody looks at this here and says, well, this is what your bylaw says, this is going to potentially open us up for litigation. Because it says, your bylaw says, and yet you're not allowing me to. So it concerns me. Separate question I have on the open space residential development. I understand that we're encouraging, it says the application of existing OSRD option is described in Article 16 of Hubbardston zoning bylaw is encouraged in the district, which is fine, it's all good. And this is again where I'm asking is where are the teeth into having something that is not only encouraged, but is actually cemented as something that becomes permanent. And I think our constituents want to have something which says, okay, this is how you're going to preserve this open space, and it's going to be preserved for perpetuity, as an example. And that you're not going to, 5 or 10, 15 years down the road come around and says, well, we had to put a pipe in here so that, this infrastructure can now work, and suddenly this is no longer open space. I'm kind of wondering, and this is more an open question for the board, how do we preserve this open space on a permanent basis? Could we grant or encourage the granting, or can we not encourage, but can we point that conservation restrictions are a means by which such open space is actually preserved?
There's some kind of
On a
agreement here.
permanent
Yeah, I thought there was
It's an
language on
It's
that.
an E1, right? Where it says the 50% shall be preserved as permanent open space is the intent behind that.
I'm sorry, who's saying what?
I'm directing you to PUD open space protection, which is item E, and then sub-item number 1, which is 50% of the planned unit development and tract area shall be preserved as permanent open space. Is Does that
Okay.
get to the heart of?
So for me, the permanent open space is what is really the crux of this here. How do we make sure that this is truly open space? It's not really a question for the bylaw, it's not a question necessarily, but how we as an entity maybe point towards preserving open space, and not only preserving it on a temporary basis or say, for example, for 10, 15, 20 years, but rather in perpetuity. I truly am very interested in making sure that our residents of our town, if we as the residents of our town are giving a permission for a gateway overlay, and everybody has very clearly stated in their answers to the questions that have been answered by folks who came in and provided their opinion. How do we go about making sure that we can preserve this here and preserve Hubbardston as a community that cherishes and grants open space in perpetuity, right? And that this does not become a blighted area just because we opened the door. And so I guess this is more a question for members of the board on how do we potentially add something here. And again, I would maybe encourage the utilization of permanent conservation restrictions.
Yeah.
And there's various entities that can be leveraged for this here. And there's certainly something that we can either work through either the special permit or maybe through other negotiation mechanisms that we do this here.
It's actually at the end of section 8.
Yeah, admittedly,
Francois.
it's poorly located, but it does. I hear you. That item number 2 is trying to do, I think, the intent of what you're saying here, the 8.B2 of this ordinance, which directs you to the end, which is all about how open space should be protected in perpetuity. Yeah.
Yeah, it is defined in the rule.
It's hard to find. I'll give you that. It's not clear.
I know I'd seen it
So-
somewhere.
I mean, I read that earlier, but I just, okay. I mean, I read that earlier, and for me, it just did not, and maybe I just have to look at this section 704 again. But it's a concern that I bring up, and it's a concern in terms of how do we manage this here, especially since we're really opening up a significant tract of land.
Yeah, I think perhaps just clarifying the reference probably gets us there, because it does essentially call out exactly what we were just talking about.
Yeah, but it's simple and honestly a good suggestion to reorganize that
Yeah.
bullet so that confusion doesn't happen. And we have a section called open space protection, and then we refer you somewhere else to talk about how it's protected.
Oh, I see. Actually, I
ought to
see it
just
now.
be-
8A2, B, the limitations.
Yes.
Yep.
Gotcha. Now I see it. I'm sorry. I had not seen that earlier.
Don't be. We probably would have left it as is had you not said that. So, I shouldn't say we. The board may have
Yeah.
left it as is.
All right, so where were we in the comment
PUD.
order? And yeah,
We're in 5.
5, okay. There I was thinking we had jumped up to 7. Additional comment on 5?
Well, as I said, I'm in favor of putting a cap on dwelling units per acre on the whole parcel, but not getting into the weeds here on how many per developable acre. I think that's a matter for the special permit process.
I would agree.
There's also, and remember, we're trying to get to the point of where we can call this a deliverable delivered. So to the extent that there's some issues that we've identified that require additional hemming and hawing for the board, we don't necessarily have to have those resolved for this to be at deliverable delivered. The stuff like the formatting, obviously, yeah, we should just fix that. That's easy enough. And some of this other stuff, but I agree with what we're saying about the numbers here, and I think that that probably leads to a more substantive discussion than is appropriate for the moment. So let's move.
Under five, section F. Are two, I was a little confused. The PUDs are going to be subject to special permit, right? Review?
Correct.
Are they going to be processed in a manner consistent with subdivision rules and regulations?
Well, there's a topic.
They're going to be subject to the special permit regulations, right?
Yeah, I can see that
I mean,
is
obviously,
currently contradictory, right?
Yeah, it is.
So existing subdivision review answers.
Because the current town subdivision rules and regulations will pretty quickly kill off any kind of reasonable PUD.
so what's the call here? Are we
So then,
going to make PUD subject to special permits or not?
if that's mine to answer, I hear you. I think that they would be subject to special permit, and that they should be, but the processing, I don't know. That's my short answer on whether they should be processed like a subdivision plans and regs. I think the intent behind it was to make sure that tree protection and other sort of elements of the subdivision rules don't have to be listed out, ad nauseum in the overlay language, that a developer could refer to those. But it does leave this board with some review peculiarities that you'd have to infer what that manner generally consistent. If the applicant is meeting that intent. I know it's a long-winded answer of saying I'm not sure.
Yeah, we might just need to figure that one out.
Moving on, I guess, dimensional standards, I had a, question about those setbacks in the case of neighborhood residential use without public utilities. Side setbacks and rear setbacks seem kind of skinny to me. I don't know, if I were a landowner abutting this parcel, I'd be a little worried about a 15-foot boundary setback, but maybe problem with dimensional standards is, of course, that they're kind of hard and fast,
Yeah.
And in any particular case, 15 feet's 5 yards. I mean, that's nothing. Now, you can compensate for that by having strict vegetative buffer requirements, and I don't see those. Are we going to require plantings on the boundary of a PUD to protect the adjacent properties from seeing swing sets in their backyard, kind of thing?
Yeah, we've not had a variance granted in town for dimensional in 5 years, 6 years, 10
Gotcha.
years.
So
You did lunch this week.
It wasn't approved though, was it? Okay, we've had one going on 10 years.
I will say the with and without public utilities, we hemmed and hawed about this one. Obviously, you get the intent here, right? With utilities, you have a reduced lot size so that you dissuade sprawl, right? You dissuade the extent of those utilities. But the without public utilities, I tend to agree with you that those are relatively tight lots, even though they are larger lots, right? The setbacks themselves can present challenges. I mean, buffer conditions does a bit address the concern about, the intent of maintaining natural vegetation where possible, but it doesn't get to your next point of, okay, so you have a setback that doesn't have natural vegetation. Should it be required to be vegetatively screened? That I think is a reasonable ask, within here as well. But maybe the neighborhood residential, we just don't qualify whether it has or it does not have utilities.
Looks like we punted it to the Conservation Commission. Actually,
Always a good strategy.
which says they may allow and require restoration and plantings.
Right.
It's most concerning, of course, in the more intensive developments, like a PUD. My final two comments. Under incentives here, we have under number 7, open space, part B, we're providing certain incentives for developers to gain additional density in the development. I'd like us to consider incentives for recreational construction. For example, use of the open space maybe for a ball field or walking trails or, some beneficial use other than just wildlife, That's just a thought, okay? Of course, that creates a bunch of issues too, like who's going to maintain it, to who's going to be allowed to use it, et cetera, et cetera. But it's an opportunity.
Well, and some of those are better problems to have than not having the resource exist.
Yeah. I'll be honest, I don't know of an incentive that is tied to active recreation or those types of things being developed, but I can look into that one and see if there's examples out there that we can pull. 'Cause I have not run into that one.
Well, even if it's just for the residents of that community, passive recreational uses for the benefit of those who buy into a community might be an important attraction. If the town and we feel that it's not something we want to get into and have responsibility for.
And sorry to cut you off, but if a developer were to do that, does that benefit that only benefits the residents of that community warrant the town allowing additional units?
That's a question for us to answer. I don't know the answer. In the absence of having an interest in maintaining some other trails in the woods by our town, I think we would have to say we'd probably want it to be maintained by the association responsible for those homes, if it existed at all. Again, this is a question as to whether this is a draw and a benefit. Maybe again it should be punted to the special permit discussions.
Yeah.
Okay.
That I think would make sense. And
Okay.
not just because we're chewing up the clock like crazy.
Okay. The last question I had, or comment, is a question about Section 8. Number, I guess it's A, I'm not too sure. 2, it says this incentive is subject to planning board review. Which incentive is being referred to here? The additional, the previous section under I? For every 10% of open space set aside is 25%.
That should be indented. That's fair. Nope, those are sub-bullets specific to item number 4. So for residential
Okay.
development where public water sewer service is available, I won't read it all. But
Okay.
in that specific
Right,
case.
it just needs clarification, that's all.
Thank you.
That makes more sense. All right, so Al, that was your list? So everybody else have an equally deep list? All right, what else do we have for questions and comments? We kind of step through the whole thing.
I didn't have time to really dive into the weeds on all the dimensional and incentive type stuff. Really looking more at big picture stuff right now. I mean, one big. I mean, this is probably more than we can roll into an effort like this, but I think it would be worthwhile thinking about whether we want, for an area like this, whether we wanted to go to a mandatory mixed use table. A number of communities are experimenting with that now, as well as the state.
Other interesting point on that, I believe on a mandatory mixed use, you're also at a 50% threshold.
Oh, what?
Instead of a 2/3 to approve it at town meeting, it's a 50%.
Oh,
Yeah, special voting rules for mixed
from
use.
state law?
Yeah.
Oh, wasn't aware of that. But that kind of changes the whole complexion of this whole,
Yeah.
Yeah.
whole endeavor.
The look on your face was pretty priceless. We weren't, I don't think anybody was
Plead the fifth on
suggesting
one.
that right
It's
now.
fine.
No, I agree that as a long-term consideration, and ultimately what we're doing here, it's a first step. There's still a lot to sort out. It's just, this is a problem that's been kicked down the road since the sand pit's closed. And we're trying to do something proactive about it instead of kicking it down to the next board. So we got to at least give the townsfolk the option to vote on something. But it's a point well taken. And also that whole 50% vote rule is something that is worth thinking about in the long run. Yeah, that's new as of last year, and I don't think the margins of it have been thoroughly explored on what counts as mixed use to trigger the voting rule. Like certain ADU bylaws and stuff like that all jump down to 50% now, which puts you into an interesting situation because going into a state-aligned bylaw, you get a 50% margin. Going out of a state-aligned bylaw, you're back to the 2/3. So. All right, anything else? Francois, anything else from you?
Nope, not at this time. Thank you.
Yeah. Well, thanks a bunch to Al, because that certainly helped drive the conversation along and was an hour and a half of comments. But it was exactly what we were looking for, so I mean it when I say thank you for putting in the extra diligence. Thank you to you and your team, because despite all of the comments, this has really been a pretty good, pretty engaging process, and we're pretty close. Obviously, there's work to do in sorting out
Sure.
some things, but we're pretty close to something I think we can put together and put in front of the town and start running some different discussions on. And yeah, there's some long-term policy implications down the road, but it's the first step.
Great. Yeah, well, I will reiterate your thanks. I truly do appreciate these comments, particularly for Al and all of you for running through this with a fine-tooth comb. That's what it's for, right? It's didn't come in presupposing that it's golden, and it's obviously not. So, plenty of comments taken down here. I'll rewatch this recording and make sure we captured everything. We'll regroup with you.
Yep. So then as far as the project goes, you're essentially going to produce a updated version, and then that's the deliverable, and that phase is closed?
Yep, that's my understanding. Yep.
Okay. Excellent.
Great.
Anything else from the board before we move on from the item? All right. Well, thank you very much for making the trip out.
Thank you for having me.
Thank you. Hope you take the opportunity to swing by Wachusett or something like that on the way home. Either the
The Bruins
ski
are on,
area
right?
or the
Yeah.
brewery.
Bruins playing Vegas, I think. So.
All right, so, and I guess I said I was going to ask if there's any additional comments or questions from the public. So I guess before we move on, any additional comments or questions from the public, or did we hit everything?
Probably not. No questions.
Yeah, good order.
Is this, I guess my only question, is this going to be, other than people watching the video, is it going to be public? So people that are listening to the video can refer to something?
Yeah, so there will be the video, and ultimately where we're getting from this is just closing out the engineering project. We haven't actually started the bylaw proposal process.
Oh, I understand
Right.
that.
So, yeah, there'll be many more meetings and a public hearing and more official process along that.
Yep.
But yeah, we'll make sure everything is available on the website.
Yeah, I think process is, next deliverable, post these revisions to you all. I think town council is the next logical step.
Yeah, town council, and then we'll be working with Alec to figure out what the rest of the process is gonna look like.
Okay,
Awesome.
great.
But yeah, be the end of the year,
Thanks.
so, thanks.
Good night all.
Oh, yep.
Mr. Chair, Mike Stahl, 5 Lombard Road. How do we stand financially on the grant that's producing this effort?
I believe we're using pretty much the whole thing on this.
It has been, yes.
Yeah,
Okay, thank you.
yep. Yeah, and there are some pending grants for some follow-up work, but I don't think we're making an announcement on any of that yet. Alec can't see that I'm looking at him.
I heard it.
We've started executing contract documents on the additional grant paperwork, but we've not proceeded to a procurement phase where we'd be retaining a consultant in some form or fashion.
All right, thank you. So yeah, more to come on that.
Thank you.
All right, thanks
Thanks
again.
all. Have a good night.
Drive safe.
All right, so moving forward, we have old business. There is none. Administrative matters. I believe we talked about at the last meeting, the changes at MRPC. Also, because of the shuffling around on the board, we need to redo the board member assignments. Although, Mark, now that you're on the board as an alternate, MRPC actually still has you listed as the alternative delegate for the commission. So, I mean, it's closer to being factually correct. The select board has Patricia listed, so there's a lot of alignment work that needs to happen there.
What a perk, huh?
Yeah. And then, matters not reasonably anticipated by chair. Anybody on the board have anything?
No.
All right, anybody have any public comment for anything not on the agenda or otherwise coming up?
No.
And doesn't look like anybody online. So moving forward, would somebody like to make a motion to adjourn?
I will make a motion to adjourn.
Here in a first, do we have a second?
I will second that motion.
All right, non-debatable. Do we have any nays? All right, we are adjourned at 8:09 PM. Thank you all for taking time out of your day.